The broadcast is now starting. All attendees are in listen-only mode.
Hello and good afternoon and welcome to the Wolfsdorf Immigration Law Group seminar, webinar. Our topic today is Immigration 101, Visa Options for Foreign Nationals. The perspective that we'll be taking today focuses primarily on HR staff. Of course, it would have relevance for the foreign nationals applying for visas themselves. We have a very substantial program. We're going to cover all the non-immigrant visa options that are available. You can use your chat function to ask questions, and my intention is to answer every question that folks may have. On the screen, as you can see, is my contact number. I'm here in Los Angeles. We do have a New York office, and you can reach us anytime at 1-800-VISA-LAW if you have questions or any concerns. We will be sending out the PowerPoint together with a recording, so do feel free to share this with your friends. My name is Bernard Wolfsdorf. I'm an immigration lawyer. The so-called claim to fame is I am the former national president of the American Immigration Lawyers Association. That is an 11,000 attorney association that pretty much represents every serious immigration lawyer in the United States. I'm just, quite frankly, just picking up. We have a wonderful attendance today, really large attendance, so thank you all for joining us. This program will run from 12:30, that's Pacific Standard Time, for about to 1:45. So we will be covering a broad range of topics, and then I will be answering your questions. I know some of you had a few technical difficulties. Hopefully you've managed to iron all of those out. Again, the chat function is available to ask questions during the program, and if you have any questions either regarding the subject matter which we will discuss or other questions generally in regard to immigration law, please feel free to contact us either now during the program or afterwards at the email address Bernard@Wolfsdorf. That is my direct email address, and 1-800-VISA-LAW will get you through to our office. So thank you again. We are going to start off with a brief discussion of options for hiring students. I'm going to briefly talk about options for hiring F1 students or new graduates coming out of college. Many of you, I understand, are experienced, so I'm just going to touch on this very briefly. Curricular practical training will allow certain students to obtain employment authorization during the academic year. The program must be related to the course of study, and such students can, in fact, be fully paid or unpaid, full-time or part-time, and the I-20 must be endorsed to reflect curricular practical training work authorization. So this can be granted for up to 12 months during an academic year. But if the student uses the full 12 months, that may prohibit them from obtaining OPT or optional practical training. These are work visa opportunities for students, and of course very useful from an employer's perspective, because there are also certain tax exemptions. And I'm not a tax expert, so please don't regard this as tax advice, but many students on CPT or OPT are in fact exempt from FICA and FUTA withholding, and that turns out to be a considerable saving for both the employer and the foreign national. Now, optional practical training is something that I really want to spend a little bit of time on because it's extremely relevant in terms of hiring fresh graduates coming out of colleges. The optional practical training is available to almost every graduating student, and it allows the student to work for up to 12, or the recent graduate to work for up to 12 months with totally unrestricted employment. The employment is supposed to be related to the course of study, but this is a very, very broad, so the employer does not have to do anything in terms of petitioning for optional practical training. Now, there's something relatively new in this arena which many employers are aware of, but which is a huge benefit for prospective employees and foreign nationals, bearing in mind that the H-1B visa is subject to a very limited quota. This is the STEM OPT, science, technology, engineering, and mathematics, but it's much broader than that. And people don't realize, for example, that even occupations in the digital arts, for example, can come under STEM, and it is possible to get a 17-month, yes, folks, that's absolutely correct, a 17-month extension to the optional practical training, allowing the student to be employed for a period of up to 29 months on optional practical training without the employer having to petition for a work visa. Of course, everything has a little hook on it, and the hook in this case is, quite frankly, the hook here is that the employer must participate in the E-Verify program. Now, that is another whole separate topic, by the way, and please mark your calendars, because on August the 16th, that is August the 16th, we will be doing a separate program, webinar, focusing exclusively on I-9 and E-Verify. So those of you who, those employers who have concerns about their I-9s and the E-Verify program, there will be a full session devoted specifically to this topic, and I will briefly touch on now whether or not to E-Verify. The program is gaining enormous speed because the government is using lures like the STEM OPT extension, where you can extend the employment authorization for your OPT students for an additional 17-month period without having to petition, and these folks are in fact allowed to continue to work in the United States on an unrestricted basis. So the STEM OPT extension, or 17-month extension, is a huge benefit. The E-Verify program is basically, it is currently voluntary. You can go to the government website at uscis.gov in order to register. I do caution that before you go ahead and register your company or a division of the company, you don't necessarily have to register the entire company. In fact, for those multinational employers who have offices in Alabama, Arizona, Mississippi, South Carolina, Utah, or Tennessee, you have no choice. As of the present time, it is mandatory to register in the E-Verify program, and almost all employers in Louisiana, Georgia, and North Carolina must also register for the E-Verify program, as are those employers who have federal contracts. So we are finding that large numbers of people are going online and registering for E-Verify. I have a very serious concern about whether employers go forward and provide the government with access to this kind of information. The government's made it very, very clear that there will be data mining your database, and you are now sort of putting your head into the lion's mouth. And before you do that, you want to make sure that you are doing your I-9s correctly, that you understand the risk that you're putting to the company, because there's not only civil violations for knowingly hiring undocumented foreign nationals, there are also criminal consequences for knowingly hiring undocumented, and you do have to, quite frankly, clean up your I-9s and clean up your workforce before participating in the E-Verify program. Otherwise, you are exposing yourself and the company, and I say yourself if you are an HR manager, and the company to potential sanctions. So this E-Verify, it's not as simple as just filling out the form and signing on. You do have to study and read the Memorandum of Understanding, the MOU, which is between the employer, Homeland Security, and the SSA. So basically, you are the right to be employed is verified in the database prior to the individual being authorized to sign. The problem is the database is not 100% correct, so there are a lot of complications involved with this particular program. In order to, or what the E-Verify program basically does is you complete the Form I-9, that is the form that is used to verify a foreign national's right to be employed, but hold it, it's not just for foreign nationals. This is a form that has to be completed by every single employee, and that has to be completed on day one of the hire by the foreign national, and the right to be employed has to be confirmed within 3 days by reviewing original documentation. We will be doing another webinar on August the 16th at the same time, focusing exclusively on this program. The I-9 is the single most complicated one-page form, in my opinion, that the U.S. government has yet produced. While the form is one page, the instructions, the M274 manual, is now over 200 pages. And this is the law. You have to verify a person's right to be employed prior to commencing employment. Otherwise, you the employer, face civil and, as I say, potential criminal sanctions if you knowingly hire certain undocumented aliens. So what this does is the E-Verify program is an automated link to the federal databases that verifies an individual's right to be employed. And when you complete the E-Verify online, you get an automated response regarding employment eligibility. You're going to get one of 3 responses. One is that the individual is employment authorized, which means that the person can go forward and commence employment. The other is that you will get a tentative non-confirmation, a TNC, where there's a procedure that has to be rigorously followed. You don't terminate at that point, and the individual has to go off to the appropriate federal agency, SSA or DHS, and correct their defect in the database, confirming the right of the person to be employed. So that, in a nutshell, is the E-Verify program. Participation in E-Verify. Now, again, this is a difficult one, whether to participate. Participation does show a good faith compliance for management and HR, showing that you're trying to do the right thing. So on the one hand, it's very, very good. On the negative side is that you are giving the government direct access to your database. And for example, I've had situations where, and I'll just be direct, whenever I'm reviewing I-9s, I tend to find an error ratio in excess of 50%. In excess of 50%, and particularly when foreign nationals are being hired, for example, on OPT or CPT, it is a very complicated process of how to do this correctly. And again, we will have a separate seminar, webinar that's going to focus exclusively on this. But getting back to the critical point here is that if you wish to get a 17-month extension of your OPT, for the STEM students, that is the science, technology, engineering, and mathematics, you, the employer, or at least the division that the individual will be working for, does have to be E-Verify compliant. So now, focusing again on participation in E-Verify, participating increases your exposure to government audits. As stated, the government is data mining those companies that comply. And participation does not guarantee or protect you against government enforcement actions. On the contrary, it may well expose you, the employer, to additional enforcement actions. The Memorandum of Understanding, that is when I last read it, at 11 pages, gives ICE, that's Immigration, Customs, and Enforcement, broad access to your company records. So before signing on, just be aware that the minute you sign this, you are basically waiving many of your Fourth Amendment rights to notice and protection that are given in the regulations, and the government then it has much easier access to your employment records, the right to come in and interview your employees and undertake periodic site visits. So everybody's being encouraged to sign up with E-Verify. They are going forward, but be aware that you're probably going to expect in the next few years that there will be a government agent come in with very limited notice because of this Memorandum of Understanding to inspect your I-9s. And if your I-9s are in good shape, well, that's wonderful. But don't be so sure that they are, because it's quite a technical process. So there has also, and just going through the pros and cons here, there has been a considerable controversy with regard to the accuracy of the database. For example, we've had situations where people get married, their names change, they haven't updated their social security cards. That will obviously result in a problem, and then those have to be fixed. So there are considerable other problems with regard to verifying remote hires, for example, decentralized. If you're headquartered in New York and you've got an employee who is on a remote hiring site, how do you in fact verify the original documentation has been seen? So some aspects of this program are extremely complicated, and then you also have state variances, which are very, very confusing. Some states will require E-Verify compliance, some states actually prohibit it, and you generally have a real haphazard framework at this point, which I will be addressing in our August 19 program and help clarify all of those points. So let's move into the area of non-immigrant work visas. Most of you are aware of or have heard of the wonderful H-1B, Professional Occupation Work Visa. What and who exactly qualifies for an H-1B? The first and critical requirement is that the position must require at minimum a bachelor's degree in the field to perform the job. So if you're thinking about hiring someone on an H-1B, you say to yourself, is there anyone currently doing this job who does not have a bachelor's degree in the field, in the specialized field? And I give some examples. There's FX artist, accountant, engineer, research associate, analyst, financial analyst. But again, if it's a financial analyst for a one-person company, they may question whether in fact that person really is performing these sophisticated job duties. The other occupations such as architect, dentist, lawyers, engineers, those are easier, but other issues come up. For example, is that person licensed? And of course, when we talk about a bachelor's degree, we are also talking about a foreign equivalent. And here's the good one. I was preparing someone last night for an H-1B visa interview at the consulate, and they had no formal education, merely 16 years of progressive experience. And there is a rule that 3 years of work experience equals 1 year of education. So if the person has 12 years of progressive experience in the field and no formal education, the H-1B option may in fact be available. Moving into the H-1B cap quota, the annual immigration fiscal year commences October 1. This gets kind of confusing because every year there's 85,000 H-1Bs come on the market, as it were, for private industry, 65,000 a year. For the general quota, 20,000 for master's or higher. That's U.S. master's degrees, by the way. There's a separate quota for Singapore and Chile. They don't actually use them up, so if you have Singaporean or Chilean nationals, they are not subject to this particular quota. Now, a little bit confusing because the earliest that you can file an H-1B is 6 months before the start date, so that's April 1. So April 1 or April Fool's Day, if you have trouble remembering it, is the day that one can in fact file for an H-1B, and the start date of that H-1B will be October 1. That will be the kick-in date that, in fact, the H-1B commences. This, of course, is the primary work visa, professional work visa for hiring foreign nationals, and it kicks in basically on April 1 every year, and you have to be ready to file. So we are still a little bit early in the season, but if those of you who are interested in filing H-1s on behalf of qualified professionals, the time to start getting ready is actually November, December, January, and get all your paperwork ready to file by February, March. You have all your paperwork ready, and then those packages need to get FedExed out, quite frankly, at the end of March, with an anticipation that they will arrive on April 1. I haven't seen if April 1 is a Sunday this year, but you really got to have your package ready and filed for April 1, and that is for a start date of October 1. We are currently run out of H-1s. There are no H-1s available this year for private industry, subject to the quota. So please get ready, and if you're an employer and you're planning, now's the time to do your hiring. And of course, these job offers must be made subject to the ability to work legally in the United States. But of course, we presently have the F1 OPT, optional practical training. So if you're looking to hire smart graduates coming out of college, many of them can be hired on OPT, and then there's a question of timing. At what point do you decide to file for an H-1B? Is this person eligible for a STEM OPT extension? Do you, the employer, want to go forward and register for E-Verify, or just move them on to the H-1B? That, of course, is the employer's decision or choice. And there is, by the way, I won't spend a lot of time on this, you do have something called a Cap-exempt organization. These are institutes of higher education, universities, colleges, and non-profit organizations affiliated with such institution of higher education. That is complex language, affiliated with, but in some instances you can in fact claim exemption from the H-1B. These organizations have what I call year-round H-1Bs, and of course non-profit research organizations, government research organizations are also exempt from that 85,000 cap. Of course, if the person already has an H-1B, they've been counted, you don't have to worry about the cap. I'll deal with that extensively. Government filing fees. Unfortunately, the government filing fees have become quite steep. You have the training fee, which is $1,500 if there's 26 or more employees, $750 if it's 25 or less. You also have a fraud fee. That is, you're paying the government $500 to send an investigator out. This is required for all individuals have to do this, and I will talk a little bit about the so-called site visits. They're not that scary if you do everything correctly. If you follow the rules and if you have good legal counsel, I'm sorry to use that phrase, it sounds self-serving, and quite frankly it is. What we find is that many of the lesser experienced attorneys are not doing the H-1B correctly because they do not do a public access file. If any of you out there have an H-1B or filed H-1Bs and you do not have a public access file, well, fix it now. Fix it now, because you're in violation of the law, and Department of Labor and USCIS, Fraud Detection and National Security are going to come and visit. They did about 25,000 site visits in the last year. Out of 85,000, that's 1 in 4. The number of site visits is actually increasing, and quite frankly, my clients don't seem to have any problem with site visits. It's a routine inspection. We have everything in order, but I get a lot of panicked calls from other employers where their lawyers haven't done or helped them guide this across, or worse still, they've just made up some of the data, and I did I do have a few cases that we've picked up recently involving Department of Labor and Department of Homeland Security special agents who are investigating on cases. So get your H-1 done right. Those are the filing fees. Here's something called premium processing, which quite frankly is a waste of time and more than that, a waste of money. Very, very expensive. It is not first class. It's just that it does render a decision within 15 business days, but I will explain why it's simply not necessary in 90% of cases to do premium processing. So the H-1B visa is employer specific. That foreign national is only allowed to be employed by your particular company as opposed to OPT, which is not employer specific. That individual is generally employment authorized and could have one or more employer at the time with an H-1B. If there's two concurrent employers, we need two H-1Bs. It can be full-time or part-time. Part-time under 20 hours a week is somewhat suspect. Two full-time is also a problem because the government doesn't quite buy the fact that you're going to be working 80 hours a week or 75 hours a week, although theoretically it's possible. Concurrent H-1Bs for multiple employers. Now, here's a very important thing, is the 6-year maximum attaches to the H-1B. H-1B, one can only be in the United States for up to 6 years. The H-1B is granted in increments of 3 years, initial approval of 3 years, subject to a 3-year extension, but we will explain why that in fact can be extended and how that can be extended beyond the 6 years. At-will employment, and by the way, folks, I do see the questions coming in. I'm going to get to them all. At-will employment, H-1B is not necessarily contractual employment. You have to make it very clear that it is at-will employment, at least here in California and other states that allow at-will employment. H-1B generally does not create a 3-year employment contract and can be terminated at any point by the employer or the foreign national, but I'll explain the consequences of that. By the way, folks, I don't normally speak this fast, but we have a lot of material to cover today. I hope you're picking up some of the relevant information, and I'm going to try and cover pretty much the whole of immigration law in a relatively short period of time. The process of the H-1B involves two critical agencies. First, USCIS, Citizenship and Immigration Services, and the United States Department of Labor. If you're an employer, you've probably worked with the U.S. Department of Labor, and all I can say is just please always remember the U.S. Department of Labor's primary function is to protect U.S. workers. They are not really your friend of the employer, and they're not the friend of the foreign national. Their job is to protect U.S. workers, and quite frankly, they take their job very seriously, which is entirely appropriate. So the first thing that the Department of Labor will do is verify the Federal Employer ID number, the FEIN, before you can even file the labor condition application. And here's something interesting about the LCA, is that this first step of the H-1B, you do have to post the LCA at the work site for 10 consecutive business days in 2 conspicuous locations. So, you know, hiding that notice isn't always smart. This is what has to be in your public access file. Some employers are uncomfortable about that, and if that's the case, well then, you know, you're not going to file an H-1B, but you do have to post the notice, and we will, if we're the attorneys, we explain to you what in fact has to be on that notice. But the LCA involves several attestations, and the most important one is that you have to pay a prevailing wage, okay? So if you want to hire a foreign national, this is not some way to import cheap labor. If you're looking at that as a way to import cheap labor, please forget about the H-1B process because this has to be done correctly. In fact, prevailing wages, which are often median wages, are the critical and the heart of the entire H-1B process. The bottom line is that you have to pay the same or similar wage that a U.S. citizen performing that job would in fact be employed. So this is probably the single biggest issue that we're seeing in the H-1B process, is that employers are not prepared to pay the same wage that a similarly situated U.S. worker would be paid, and that's not only wages but benefits. So this is the actual wage. So if you're planning to hire the foreign national, and pay them discretionary bonuses, commissions, or other variables, that is not acceptable. Benefits generally don't count. They're looking at what is the cash wage that the individual will receive. So this is very rigorous, and you must offer not only the same salary to similarly situated U.S. workers, but also the same benefits. So if you're planning to only give benefits to U.S. workers, again, the H-1B process is not the correct one for you. Again, certain other things, no strike, no lockout, and in fact, you have to keep the public access file, which I have already mentioned at least 2 or 3 times. I will keep talking about it because it is absolutely essential. Can the LCA be posted? I'm looking at some of my questions because there's great questions flowing in here. Can they be posted electronically? And the answer is yes. There is a procedure for electronic posting of LCAs, but in fact that has to be sent out to the entire workforce. So that's a fairly rigorous procedure that you have to in fact pursue. So let's talk a little bit about the H-1B process. The steps that we have here is first, once you have the approval from the Department of Labor, you have your LCA certified, you can then submit your application to the USCIS. That will consist of your support letter with very detailed job description, evidence of the qualification of the foreign national, the various forms that need to be filed, and of course the government filing fees have to be included. What is the current processing time? The current processing time I'm putting there is 3 to 5 months. So if you file April 1 through the regular processing, you may not get a decision until, let's say, August, July, but that's not a problem if you have OPT, and we'll talk about cap-gap and cap-gap closing and other complicated things, but there is basically a way to close the gap between the end of the OPT, which say would be July 1, and the start of the H-1B, assuming it's approved, which is October 1. The H's from what I'm going to call last year's season are just kicking in the next month or two, and then the individual can in fact enter 10 days before October 1, which would be September 21. Now this premium processing, a lot of people do waste their money with it. 15 calendar days, you file the petition, you get it approved, that's wonderful. Or what happens is you get an RFE, request for evidence, on the 15th day. People feel that you tend to get more RFEs when you in fact use premium processing, and we have seen that. I don't make any accusations about the government whether or not you get value for your for your premium processing for your $1,225, and there's only limited circumstances where I recommend premium processing because in fact and that's usually which involves situations of travel, where the individual needs to travel abroad and get the visa stamped, and there are other limited situations where you're trying to get 3-year extensions for your H-1B because you've gone beyond the 6-year limitation. So let's talk a little bit about the employer responsibilities. If you have additional worksite, is a really big deal. On an H-1B, you have to indicate where the person will be performing services, and if you are changing the work site, the question is, does the labor condition application cover that new work site? Do you in fact require an amended LCA? Do you in fact require an amended petition? Those are very, very big issues, and people are not aware of this. So when you get your site visit, the Homeland Security Inspector will go to the work site designated on the form, and if the individual is not there, well, then the question is, why didn't you file an amendment? And that becomes a serious issue. Now, in terms of employer responsibilities, and trust me, there are many, people need to be aware that if the individual is terminated prior to the completion of the H-1B, they must offer the reasonable cost of return transportation home. So this is an airline ticket back home. It's a civil obligation. You must also notify USCIS that the individual has been terminated. And you actually want to withdraw the H-1B. We actually notify the Department of Labor as well, because there have been some decisions, hold your breath folks, which say that you're on the hook and liable to pay the wage until such time as you have notified USCIS and withdrawn the H-1B. I don't make this stuff up, folks, but you do need to follow the rules. The H-1B is a viable visa. It works. That's what we do for a living. We file them all day, every day. But the bottom line is you have to be 100% in compliance. Now, no benching. Most of you employers know what benching is, but for example, if you do a furlough of workers, you've got a problem. So if you do a one-day furlough, you want to cut back hours, you cannot do that for a foreign national. In some ways here, the foreign nationals in a better situation than the U.S. worker, because you can bench the U.S. worker if you don't have enough work, but you cannot bench the foreign national. You are on the hook for that salary as explained in the labor condition attestation, unless the foreign national actually voluntarily requests a leave from the employer. If the foreign national voluntarily says, look, you know, I would like to only work 30 hours a week because I'm going to go and do a master's degree, and that is voluntarily requested, and the employer authorizes, then you can reduce the number of hours on the labor condition attestation. Use of contractors, this is a big deal because a lot of problem is that the posting has to be placed at the job site where the contractor is working. So some large companies may be using some of the so-called contractor H-1Bs, particularly in the tech arena, and it is necessary to post at the job site, even though you, the employer, are not the direct employer of that foreign national. So this is very, very important to note that if contractors are placing H-1B workers at your site, you are required to, in fact, post the LCA, labor condition application, or specifics of that job. Training fee. Training fee must be paid by the employer. We've got some questions here. I'm going to go through all of them. I just want to see if I can cover this huge topic. Training fee must be paid by the employer. The fraud fee or other government filing fees can be paid by the foreign national or the employer. Some people take the more conservative view that all fees, legal fees, filing fees, fraud fees, everything has to be paid by the employer. My read of the regulations is different. My read of the regulations is the training fee must be paid by the employer, but the fraud fee and other government filing fees can be paid by either, and that the legal fees can be paid by either the foreign national or the employer. However, there is a very, very significant however, and that is that if you, the employer, are paying exactly the prevailing wage, and let's assume the prevailing wage is $60,000, and the foreign national is being paid $60,000. At that point, the government takes the position that if the foreign national pays any legal fees or any government filing fees, that will be reduced from the prevailing wage, such that you then have a prevailing wage violation. And trust me, the site visits, and many of you have probably had them already, they ask these questions: who paid the fees? And if you are paying exactly at the prevailing wage, then the foreign national cannot pay the legal fees or the fraud fee or the other government filing fees. So let's assume in this example the prevailing wage is $65,000, and the prevailing wage is $60,000, and the foreign national is being offered a salary of $65,000. That may well be permissible for the foreign national to then pay the fraud fee and the government filing fee, and the legal fees can in fact be paid by the alien or the employer. Presumably, all of that would come to under 5,000. Let's be hopeful. So let's talk a little bit more about H-1B audits. I've already kind of scared you a little bit with those, but you know, if there's a speed trap, you don't want to be driving in excess of, if there's a radar and that police officers focused on your automobile, you don't really want to be exceeding the speed limit because you're going to run into some trouble. Of course, if you drive at or below the speed limit, then you don't have any trouble and there's absolutely nothing to worry about. But there's been a huge increase in so-called site visits, so-called fraud investigations. We are pretty clear. The government has announced and has conducted at least about 20,000. And note, these are unannounced site visits, So what happens is you better instruct your receptionist that if somebody from Homeland Security is at the front door, you know, what do they do? Who do they give permission to? You need to make sure that all your receptionists have a direct link to the HR manager or the chief counsel, or call 1-800-VISA-LAW. But yes, I do in fact often instruct our clients to call us immediately upon receiving the site visit and to make sure that they have the public access file and all the documentation ready for the officer so that they can make sure everything is in order. Timing issues. Now, perhaps the most complicated aspect, or at least one of the most complicated aspects of the H-1B process is when to file your H-1B. As I mentioned, the earliest one can file the H-1B is April 1 for an October 1 start date. From 2003 to 2009, we had something that we used to refer to as March Madness. There were basically lotteries, and the H-1B visas would sort of run out in 1 or 2 days, and then I would always get employers who would call me and say, I want to do an H-1B, and I'm like, well, you didn't read our newsletter, and by the way, I encourage all of you to sign up to our newsletter. You can go to our website, which is my last name, Wolfsdorf, Wolf like the animal, S-D-O-R-F. That's wolfsdorf.com, and sign on to our newsletter. We will notify you with all news regarding immigration benefits. We publish our newsletter usually twice a month, and we explain all of these things, and we will remind you about H-1Bs and when the H-1Bs run out, and still every year we have people calling who missed the H-1B season. So talking a little bit about timing of H-1Bs, after 2009, which is when sort of the recession really started to take hold, the cap was reached on December 21, 2009. So for the period from April 1 of 2009 through till December 21, 2009, there were H-1Bs available for a good portion of the year, and people who missed them only had to wait, what can I say, in that instance about 10 months before being able to hire the next group of qualified professionals. Quite frankly, this whole thing is ridiculous because there can be the best qualified candidates coming out of a PhD program with cutting-edge skills in computer science or engineering, a graduate from Stanford or Harvard or wherever, and simply not possible to hire them other than on OPT because of this cap issue, but it wasn't such a problem, at least for the last 3 years. But in December, for fiscal 2010, which starts October 1, the cap was actually reached on December 21. So for the period from April 1, 2009 to December 21, 2009, there were H's available. For the next fiscal year, 2011, the cap was only reached even later. At that point, visas were available all the way through till January 27, which was the last day that the H-1 quota expired. Now, fiscal 2012, oh my gosh, are we seeing something different happen? Now the direction is going the other way. And by the way, folks, this is the first sign that the economy may be picking up, and that is that the cap in this instance was only reached on November, well, was reached as early as November 22, 2011. My personal prediction is you're going to see a very different story this year. And if you're not ready to file in April 1, my prediction is we could find the H's running out within a month, or we could even find them running out within a week. So if you're planning on hiring foreign nationals, or you've got foreign nationals currently on OPT and you want to file H1s, you better be ready to file on April 1, or you may well find yourself losing out. Folks, new rules for F1Bs. They're not that new anymore, but I want to basically talk about cap gap relief, or cap gap relief. Is that cap gap, gap cap? It sounds like Dr. Seuss. I always get confused which order it comes, but the good news is that what this allows you to do is to close the gap between the end of the OPT, which could be July or August, and the start of the H1B, which is October 1. So this allows F1 OPTs who file a petition during the acceptance period on or after April 1 to continue to be employed all the way up until the H1B kicks in on October 1. So what happens here is the OPT employment authorization is automatically extended. The student does need to get an endorsement from the international advisor on the I-20, but that is usually readily given. So cap gap relief is a huge benefit for foreign nationals. Let me give you some idea of timing issues here. So we have a situation where a student graduated just in June 2012. OPT is now kicking in July 2012. By the way, for years and years, I've always explained that the individual has to apply for OPT within 60 days of completion of their course of study. The government is enforcing a new rule that actually the OPT has to be filed within 30 days of endorsement by the international advisor. So we have a whole lot of graduating kids this year whose OPT is being denied because they waited more than 30 days and thought they had 60 days after completion of studies in order to file for OPT. Optional practical training, wonderful work visa. The individual now is authorized to start work in July 2002. They could file an H1B as early as April 1, 2002. Do I have a typo here? Yeah, I do have a typo here. They could file the H-1B as early as April 1, 2013. We need to correct that before we send that out. That's my snafu. That if the individual, in fact, has OPT, which it starts this year in July 2012, and they would then want to consider filing for an H-1B on April 1, 2013. In this instance, if the OPT ends on July 2013, remember this is a 12-month period, the cap gap, and this is the relevant point of this slide, is that the time between July 2013 and October 2013, that is the so-called cap gap relief. You can get an automatic extension for that 2 or 3 months until the October 1 start date. So this is a very, very good thing, but this is, of course, only if there is, in fact, an H-1B available, and you have cap gap relief, of course, ends upon rejection, denial, or revocation of the H-1B visa, and at that point the individual gets a 60-day grace period to pack up and leave the country. I apologize for that typo, but the bottom line is that in the particular pattern that we have, and the critical operative point here is that the H-1B can be filed as early as April 1, 2013, that is for next year's H-1B cap for those folks whose OPT just starts in July of this year or August of this year. That's cap gap relief. Now, H-1B portability. An H-1B can port or transfer to a new employer at any time. This is very, very important. Once the individual has been selected for an H-1B, they are no longer subject to the cap, and the new rule is that the individual can, in fact, start employment upon filing of the new petition. They do not need to wait for the approval, no need to pay for premium processing. So if somebody already has an H-1B, they can in fact file with the new employer and commence employment immediately upon filing of the second petition. There is an exception to this, and that is if the individual had a Cap-exempt H-1B. For example, they were working in a university and then they moved to a private industry, that in fact becomes Cap subject, and the individual cannot use the portability, that is the filing of the petition, which is in fact the work authorization. And I can get more complicated than that if we have concurrent employment with the Cap-exempt. So if they stay a half-time or 50% with the university, 50% with private industry, and they have concurrent, then they can in fact use it. But let's not go into too many of the issues. Two of the options. The important point is the individual doesn't need to leave the U.S. When requesting the extension of stay, or it is also possible when you file that second H-1 for the individual to request consular notification, and in that instance you may in fact want to consider premium processing. H-1B remainder option, this is sort of very, very important. You have only your 6 years of H-1B, and if the individual is in fact outside the United States for some of that 6 years, they can recapture that time, and if they've used up their full 6 years, then they have to go back home for a year before they can in fact obtain another 6 years of H-1B. I'm going to try and move forward a little bit in terms of time. Recapture time spent abroad. The other, and this is a very, very important point, is that if you want to extend beyond the 6 years of H-1B, you have to have a green card application pending for at least 1 year. So if you file a labor certification that is a green card based on employment pending for at least 1 year, then it is possible to extend. So if you have filed for a green card before the 5th anniversary of the H-1B, then you can in fact extend beyond the 6-year cap. So the other situation is that if the I-140, which is the immigrant visa petition, has been approved, but the category is backlogged or retrogressed as we currently have, particularly for Indian and Chinese nationals, you can in fact get 3-year extensions of the H-1B if the I-140 or immigrant visa petition has already been approved. A few myths about the H-1B, that you can't get them for small companies or startups. It's true that it's a little bit more difficult with small companies or startups. There's also some confusion that whether or not the position has to be advertised. That is not required. Whether or not the individual can change employer if the H-1B cap is reached. The bottom line is that such individuals can in fact change employers. And that there's a new 6-year period if they change employers. So if you're out there hiring H-1Bs and somebody already has them, you, the employer, need to be a little bit concerned if the individual already has used up 5 years of H-1B time. If at that point in the green card application hasn't been on file, you're only going to get that H-1B employee for 1 year. The idea that they cannot go to school part-time on an H-1B is not true. They can, in fact, study on an H-1B, do a master's, but the primary purpose rule then kicks in, and the individual has to be primarily working as opposed to studying. Unfortunately, for spouses and children of H-1 visa holders, the individual is not the spouse and children are not employment authorized, but of course can in fact attend school. The H-4 spouse, if she or he want to work, have to get their own separate work authorization. Let's talk about some other alternatives to H-1Bs. Free trade agreements. We have H-1Bs for Chile and Singapore that actually have separate visa quotas, and these individuals get an 18-month visa. So if you file under the free trade agreement, the visa is actually limited. They can, in fact, transfer to the regular H-1B, but then they become cap subject. So you have to factor in the question of, is there a visa, in fact, available? Let's talk a little bit about Canadians and Mexican nationals. Very, very good news on this side. The job must be on the list of occupations, the professional occupations, so-called scheduled to the NAFTA Free Trade Agreement. Canadians apply at the border and are basically authorized to come in for a period of up to 3 years. Very popular, the Canadian TN NAFTA visas. Not that easy, still have to comply with all the rules and regulations. Mexican nationals have to apply at a U.S. embassy or consulate in Mexico. They get 1-year visas but can in fact get 3-year admissions. So these visas are available for professionals coming from Canada or Mexico, and they do have to fall within this relatively narrow sphere of professional occupations. They also have to show temporary intent, no intent to immigrate, and the spouses and children, even if not Mexican or Canadian, are eligible to obtain TD or treaty-dependent visas. What about other options? I see we had a question here. Is the information the same for E3s? E3s are the Australians. The E3s, yes, many of the same requirements. You'll get this Australian will come in and say, oh, no problem, no problem. But they also have to have the LCA, the labor condition, the posting notice, the prevailing wages. This is a special visa available for Australian nationals, very similar to the H1, 2 years, renewable indefinitely, apply at the U.S. Embassy or Consulate in Australia. Here's the wonderful thing about the Australian E3 is that spouses can, in fact, obtain unrestricted employment authorization. It takes about 60 to 90 days for us to process these, but spouses of Australian nationals are free to work wherever they want and do not, in fact, have to be engaged in a professional occupation. All right, let's jump on board with the L1, that is the company transfer visa. This is for multinational executive managers or people with specialized knowledge. The requirement is they must have been employed for 1 year abroad in the 3 years prior to the transfer by an affiliate, and the position must have been executive, managerial, or specialized knowledge. So L1 is wonderful, wonderful work visa. This is what multinationals use to transfer folks around, and they have to be coming to the United States to fill an executive, managerial, or specialized knowledge position. So the L1 is not subject to the quota. The fraud fee, of course, does kick in. So, be ready, make sure you're compliant, and do all of this stuff correctly. A lot of people think, well, immigration law, this is easy. We go to the website, we download the information, we fill out the form, and gee, it's not. Immigration is a very controversial issue with the high unemployment we have here in the United States. Right now, you better make sure that you're doing it correctly, because those people who think they can cut corners are making a very, very big mistake. Homeland Security is not an agency you want to mess with, nor Department of Labor. There is a way to do it, and you do it correctly. You do not break the rules. So let's talk a little bit about my absolute favorite visa, which is the blanket L1. This may not apply to many of you, but here's the good news. It's basically the L1 visa, and you can read that whole page or not. The simple bottom line is that if the U.S. subsidiaries and affiliates, there's 3 or more domestic and foreign branches, if you have 3 or more domestic or foreign branches and over $25 million in annual sales, you may well be eligible for a blanket L1, which allows the individual to go directly to the embassy and pick up the work visa. What's the bottom line with the blanket? If you are a big company and you meet these requirements and you don't have a blanket, call me right now, 1-800-VISA-LAW, because you need to get one. And if you have people who meet the requirements for company transfers, they simply go directly into the embassy and pick up their visa if they are managerial, executive, or specialized knowledge. So the L1 blanket is truly a wonderful option for major multinationals who plan on being transferred into the United States. The L1B visa, which is a specialized knowledge, is available for 5 years. The L1A managerial is available for up to 7 years. And here's the good news again, folks. Spouses and children are eligible to receive L2s, and the spouse can, in fact, apply for unrestricted employment authorization. And then the wonderful news here is that the L1A, that is the managerial or executive, can apply for a first preference, what I call EB1 fast-track green card. So everybody pretty much knows this. If this individual is, in fact, on an L1A, they may well be eligible to flip that over to a first preference green card, which is a very, very fast green card. Sometimes we finish these cases in as little as 6 to 8 months for major managerial. So definitely an option to consider. Folks, as always, I've put too much material, so I'm going to actually speed up and try and cover the rest of our topics today. My tech person has reminded me to encourage you to like us on Facebook and to follow us on Twitter, and you will get all the necessary information you need for our upcoming seminars. We put on seminars at least once or sometimes twice. We've just scheduled a I was mentioning my August 16 seminar on I-9s, but we're also doing now another one on deferred action for the Dream Kids. This is the new program just announced where the estimate is 1.4 million kids who basically came here as children and grew up, and they're undocumented. They look like Americans. They sound like Americans, unlike me, who is a naturalized American. But in every respect, these are kids who really have grown up here, went to high school here, and they are, in fact, undocumented, and they're going to get a chance to get work permission. So this program starts August 7th is our webinar, and they'll be able to file just a week or so after that. August 15th is the kick-in day. That's the deferred action program for children, young people who are currently under 30. So back to our L1A program. The L1 is the individuals eligible for up to 7 years. They can fast-track on to green cards. Moving forward, just because, I'm sitting here in Los Angeles, I want to talk very quickly about the O1 visa. The O1 visa is available for anybody, literally anybody of extraordinary ability and in this case, I'm going to deal with arts, motion picture, TV, music, but the O1 is for individuals of extraordinary ability in art, science, education, business, athletics, covers pretty much everyone. There is a standard for the artist. There's different types of O1s, but the standard for the artist visa or entertainment visa is that the person has to be extraordinary, which is defined as a skill or recognition significantly above that ordinarily encountered. So it has to be significantly above that ordinarily encountered, and then they have to meet one of the 3 criteria in order to qualify for the O1. This is a wonderful visa approved for an initial period of 3 years and renewable indefinitely. There are many, many top people in the arts who are on O1s with no intention to become green card holders. This visa is also available for other categories in the O1s. There is, for example, the O1, which is the alien of extraordinary ability in science, athletic, business, or education. This one is different. This one is for the small percentage who've risen to the very top of their field. Ouch. That's quite a tough one. So this is an even higher standard for people who, but I want to talk about options because in many instances people have missed the H1 and this is the only other option that they have available. Reasons to consider the O1 visa: if they've reached the 6 years of H1B and you don't want to let them go, maybe if they've met this very high standard, they can in fact flip over to O1s. The H1B quota has been reached. So you may want to go into that. For the arts and entertainment, this is the preferred visa. This is the lower standard, and there's no real prevailing wages, but the issue here is that the individual does have to generally show that they are top-notch, and if they're earning minimum wage, then question is, are they in fact very capable? The other reason to do an O1 is if the person has a J1 visa and is subject to the 2-year home residence requirement. It doesn't quite override the J1, but it exists simultaneously with the J1. So the O1 is not a solution to people who are subject to the 2-year home residence requirement. Folks, I apologize if I'm a little bit technical here, but I'm just trying to cover the whole of immigration law in about an hour and a half. So I am expecting you to call or email if you have other specific questions. The spouse of an O1 gets an O3, can attend school, but unfortunately the O3 is not a work authorized category, unlike the H, L, or E, which in fact will allow a spouse to scratch that. The H spouse does not have permission to work, but the E spouse and the L spouse can in fact get work authorization, as can the J2 spouse. O2 very quickly, but if the individual is tied to the O1, assists in the performance of the O1, has a pre-existing long-standing relationship, and is an integral part of the performance, the O2 can in fact qualify. This is kind of important because in many instances you may have a director who wants to bring over their whole team, and they can bring in, the support team on O2s. This is only for people in arts, motion picture, and TV, but the O2 is a visa that we regularly and frequently file when we're bringing in large groups of entertainment folks. We have the one top person and then their key supporting team. J1 interns. The J1 program is a wonderful program. There are various different types of interns. There's the 12-month intern where the person is currently enrolled in a degree abroad, or where the individual is in fact graduated from such institution no more than 12 months prior to the start date. These have to be structured intern programs, and this is another way to bring individuals into the United States if they are legitimate interns or trainees. The other one is the 18-month J training program. Most of the large companies that I represent have their own J1 programs. We can talk about how those are processed, but for the 18-month, the individual has to have a degree or professional certificate from a foreign post-secondary institution and at least 1 year of work experience, or, and here's the big or, if the individual has 5 years of work experience. So we've had situations where an employer will call me, we have to bring this person over, we want to bring them over as a trainee, they have 5 years of work experience in the field, and the J1 can in fact be an option if they're coming to train. Note, no productive employment or only productive employment that's incidental to the work, but the J1 is an option to bring in interns and trainees if you in fact have a structured program. Other trainee and work visa programs, you'll see this, kids coming from Australia, New Zealand, South Korea, or Ireland. These are specific J1 programs where there's no sponsorship directly from the employer. They already have. This is almost sort of a self-sponsored J. There's organizations that sponsor them, but particularly popular from Australia, and the Korean one is gaining ground as well. There's also the other category of H3 visa, can be approved for up to 2 years, where there is a detailed and structured training program. E1 or E2, this is the treaty trader or investor visa. There's over 80 countries that have treaties with the United States. You've heard of, for example, NAFTA, Mexico, Canada, most of the European countries. In the Asian arena, China does not, Taiwan does have the treaty, India does not, Pakistan does, so it's kind of a little bit haphazard, but if there is a treaty and the company is at least 50% owned by nationals of that treaty country, so some of the major, for example, Japanese, Toyota, they have the ability to, in fact, bring in certain key executive manager or essential employees. If the company is at least 50% owned by that nationality, then individuals with Japanese nationals, for example, or as I say here, Australian nationals, can in fact come in under the E2 category. Very popular for executives, managers, or essential employees. R1 religious workers, this is again just for people who have a religious occupation or vocation. This includes religious professionals, teachers, instructors, musical directors on the R1 work visa can be approved for up to 5 years, and of course the person who is in a religious vocation where they've made the commitment, they ordained, they come in as under religious vocation. These visas are generally processed relatively quickly, but please, again, everything I say, they do have to be genuine visa categories. Okay, green cards. Well, you know, I'm going to cover the whole of green cards in all of about 3 or 4 minutes. I'm going very, very fast on this one. I have to talk about the green card lottery program. You don't need a lawyer to do this. There's the website, travel.state.gov. Remember the double dots, triple dots here. It's www.travel.state.gov, the State Department website. 50,000 green cards issued every year. They send out about 100,000 winners. So if you have individuals who are from countries that are eligible to apply on H-1B, they may want to take a shot. Again, it's a lottery. I don't know why people who always think they're going to win when they buy lottery tickets, but that's how it is. The program takes place in October or November, and they must be eligible. The high contribution countries are listed above who are ineligible. However, if those individuals are married to somebody from an eligible country, both husband and wife can in fact apply. Please note that in the past, people born in Hong Kong, Macau, and Taiwan have in fact been found eligible and are likely to continue to be found eligible. But certain countries like Canada, UK, South Korea, China, India, those are the countries where most immigrants come from, are not eligible to participate in the green card lottery. That list changes every year, so sign on to our newsletter and we'll give you the latest news of where to apply for the green card lottery. Family-based immigration. This is kind of obvious. You have the immediate relative, spouse, parent, or minor child of a U.S. citizen. These are really fast. They're processed in a few months. If it's marriage, it's got to be a conditional green card. People always come and tell me, oh, I'm going to marry my girlfriend to help her get a visa. Please don't do that. It's only 5 years in prison for committing marriage fraud. But then again, they could add the $250,000 fine. So that's about the same penalty as bank robbery. So people, I don't know why they think about doing phony marriages, but please do not call 1-800-VISA-LAW if you have a phony marriage. We are not the right law firm for you.
You should be. I apologize for that, folks. We seem to have had what I would call a sound snafu, but we are back and live, and I hope all of you can hear it. I'm not quite sure what exactly happened there, but being a lawyer, my technology skills are not very good. So we're just talking about family immigration, and we were having a whole lot of fun. Immediate relatives. Yes, you can hear us. Woo! Relief. Family immigration, immediate relatives, spouse, parent, minor child of U.S. citizen, very fast green card, immediate benefits, work permit after 3 months or so. It takes about 6 months to get an appointment. Conditional green card is 2 years from the time the green card is issued. They have to file to remove. An adult child has to be at least 21 years of age, U.S. citizen, in order to petition for their parents. These are all the other second preference, third preference, all the other categories of green card for family-based immigration. They have one thing in common: long waiting lines, in this instance minimum 3 years, maximum 15 years, some nationalities 25 years. So the bottom line is green card waiting lines are terribly long for family immigration. Employment-based, first preference immigration. This is for aliens of extraordinary ability, outstanding researchers, professors, and multinational executives and managers, which I've already spoken about. You have 5 categories of employment-based immigration. This EB1, the best and the brightest, no waiting lines. You have the second preference, EB2, Schedule A Group 2. Many of you haven't heard of that. That's one of my favorites. That's for people of exceptional ability in art, science, or performing arts. We do tons of those visas, and it seems like a lot of my colleagues don't know about that one. You need to have an advanced degree for EB2 to qualify as second preference. That is a master's or higher, or a bachelor's degree plus 5 years of progressive experience. Falling under the second preference category is the national interest waiver, and also you have the special handling cases for university, college, or teachers, which are processed very, very quickly. Special provision here for special handling cases is that the individual only has to be the most qualified individual. Third preference, employment-based. Long waiting lines, folks, for the employment-based third preference. These are people with bachelor's degrees or skilled workers with two years of work experience in the field. There's an other worker category where they have less than 2 years. This is the nannies and the child care, and of course those two are also subject to long waiting lines. Now, why does it matter, EB2 versus EB3? Well, because we have something called retrogression. The China and India quotas for third preference are ridiculous. The China and India quota for second preference are a little bit less ridiculous, currently at about 2 or 3 year waiting line. By the way, there is legislation which may go through, which is going to even the playing field. If that legislation goes through, China and India will be the same as everybody else, but we're probably going to find backlogs develop for other countries besides China and India under the second preference, that is the master's degree or bachelor's degree plus 2. Bottom line here, folks, is the immigrant visa category is for the second preference is for masters or bachelor's plus 5. Sorry, folks, I just need a little technical issue I just have to deal with here. So we've got an EB2. We had a little bit of a technical. I don't know what's happening with the technical stuff here. Okay, I'm going to just keep going, even though I can hear my own voice reverberating, and there's nothing I can do about that. The China and India quotas are considerably backlogged for third preference, and many of the folks who qualify because they have a bachelor's degree and 5 years experience may want to kick up to the EB2. So very quickly now, because we're kind of running out of time, the PERM process. This is the process whereby you can convert an H-1B to a green card. This is the PERM labor certification where the employer must in fact conduct good faith recruitment efforts to show that there are no qualified U.S. workers, at least 2 newspaper ads as well as 3 other forms of recruitment have to be undertaken in order to show the good faith employment. The second stage of the PERM process is filing the immigrant visa petition or I-140, and then if your priority date is current, meaning your place in the waiting line is current, then you are eligible to adjust status in the United States, and about 60 to 90 days after you adjust status, the individual is granted a new work authorization and in fact a travel permit. Now this is the visa bulletin. I mentioned this website before, travel.state.gov, or you can simply Google the term visa bulletin, and everybody who's filing for a green card under employment needs to understand how this works. So you'll see their first preference, all current, no waiting line. Processing of a green card as little as 6 to 8 months. Second preference, unavailable. Hold it. Unavailable. There are 0
0 green cards available for the rest of this year until October 1 if you come from India or China. And if you come from the other countries, the case must have been filed in January 2009. So considerable waiting period there, currently about 3 years from every other nationality, even under the master's degree category. People are shocked. I mean, if I say, well, look, we've got the Stanford graduate in computer science with a master's degree, and it's going to take 3 years to process a green card if they were born in Canada, and if they were born in China and India, there's actually no green card currently available for you. So, you know, we're in many instances sending our best and our brightest back home, which makes 0 sense. Interestingly, there are visas available for under the third preference category in these things, because so few people, basically what this means is that so few people have filed under the bachelor's degree category coming from China, because the waiting line there is 7 years. And so many more have filed under the master's degree category that it's now absolutely shut down. Other workers, that is the less than 2-year experience. Fourth preference is current. That's a special immigrant. I mentioned the religious workers and certain other categories. So perm issues, deciding between EB2 and EB3. This is really not based on the foreign nationals qualifications, but has to be based on the actual minimum requirements for the job. When you're filing perms, everybody likes to tailor them to the foreign nationals' experience. That's not a good idea. And alternatively, putting in foreign language requirements, also not smart. Generally, you cannot use employment experience gained with the sponsoring employer, because you hired that foreign national without the experience. So why not give an American the equal opportunity to compete, which makes total sense. Common green card issues. When to start the green card process? You have to start no later than the 4.5 years into the H-1B process. Why? Because that green card application has to be filed before the 5th anniversary of H-1B in order to be able to extend the H-1B beyond the 6-year period. So 4.5 years, generally the deadline. If you can do it at 4 years, that's great. Generally, most companies will commence sponsorship at 1 year. That depends on your company sponsorship policy. So the green card application has to be pending with the Department of Labor for at least 1 year, and then you can extend the H-1 in 1-year increments. Once the I-140 or immigrant visa petition has been approved, you can then extend it in 3-year increments. Other immigrant visas, I mentioned the EB4 religious worker category, and then EB5. So employment-based, we have first preference, second preference, third preference, fourth preference, fifth preference. First preference is the extraordinary individuals, the PhDs, outstanding researchers, and the managerial transfers. The second preference, master's degree or bachelor's plus 5 years equivalent. Third preference, bachelor's or 2 years of experience. And then fourth preference, religious workers. EB5, by the way, the EB5 program is red hot at the moment. A lot of Chinese investors. We've done 2 or 3 webinars just on the EB5 program. Some of those are actually on our website, by the way, if you have time. Or pretty much all of our past webinars are in fact recorded and on our website and available for you to listen. So if you want to listen to these on your own time, please feel free, share them with your friends. Bottom line with the EB5 program, it's a $1 million investment and 10 direct jobs in a new commercial enterprise. I get this call every day. I have a business, I have a Chinese investor, they want to put $1 million in, and I'm like, okay, so where are the new jobs? I didn't know about that. That's a job creation program. And then you have the regional center program. There's currently about 225 regional centers. You invest $500,000. And the big one here is that they're allowed to create indirect jobs. But that's another whole 3-hour discussion. And again, we do several webinars on the EB5 regional center program because, quite frankly, it's red hot. A lot of kids graduating from schools cannot get H-1Bs, and they have parents who are prepared to invest $500,000 to help them, and get green cards. So maintaining a green card, now we've got the green card, we are coming to the end of our program, folks. Extended absences create issues. If you're going to have a green card and be out for more than 6 months, you may want to consider filing for a re-entry permit. People think it's 1 year, but the bottom line is you need to show that you are maintaining your ties. Re-entry permit, very good thing if you have a green card and you need to be assigned abroad and you're going to be working abroad and out of the United States for a period of more than 5 months. I always advise my green card holders never to be absent for more than 5 months, particularly if they plan on applying for U.S. citizenship. Which takes us to our final topic of naturalization. Employment-based and family-based immigrants, generally 4 years and 9 months, they can apply to become American citizens. Spouses of U.S. citizens, that's 2 years and 9 months, so they get 3 months credit for being the spouse of a U.S. citizen. They must have been physically present in the United States for 50% of the time, and they cannot have been out for more than 6 months at a time because that breaks the continuity of the residence. Of course, there are exceptions to everything that I've said, so that can be explained in certain situations. Dual citizenship varies from country to country. China doesn't allow it. India now does. This has changed. It varies from country to country, but in many instances, dual citizenship is, in fact, available. Folks, we have, I'm only 10 minutes past time, which is unusual for me, but we have now covered, yeah, that's my little smiley face. Don't know how funny that looks, but there's all my contact information. Email me, call us at 1-800-VISA-LAW. I hope that you found this interesting. Please register for our upcoming webinars, and we have numerous topics. And I'm going to take a look at some of the questions that we have. So for those of you who've put your questions in, I'm going to see if I can answer them and fly through them. I'm probably not going to cover all of them, but let's go to the beginning and see where we are. Please advise, I'm calling, which are the employees in North Carolina that are not required to e-verify? That person's left. Okay, is there a 40-hour limitation for such employee? Generally, yes, if they have multiple, the government, this is the situation of the concurrent employer. If you have 2 concurrent H-1s, the idea that you're working 40 hours a week in both, does raise some issues. So generally speaking, I prefer to have one as a part-time H-1 and the other as a full-time. This is excellent. Keep talking fast. Oh, that's funny. Thank you for that lovely comment. We do like compliments. So if you have anything good to say about us, please email us. You can be anonymous, and we'd be delighted to hear from you. If you have anything that is not good to say, send it in any way, and I'll try and get better in the next one. I try to have a little fun with this stuff. As you can see, I'm kind of a happy little individual. It's I always like to say it's because I have a lovely family with 4 beautiful children. If an F1 student working on STEM extension changes employer, does the USCIS need to be notified? Not by you, the employer, but yes, that information has to be conveyed back to the international advisor, the DSO. Can LCAs be posted electronically? Yes. Do we have to pay transportation and wage if they choose to terminate employment, or only if we terminate employment? I really encourage all of you who file H-1Bs to look very carefully at the return transportation option, but the general requirement is that you have to offer to pay the regular price of return transportation ticket back home. The question, of course, if the individual doesn't go back home, why are you paying this? So you offer to do it. In some instances, I have recommended to employers that they offer to reimburse once the ticket has been purchased, but that may be a little bit aggressive, and probably the safe thing to do is to offer to pay the regular, obviously you don't have to pay first class airline ticket, but you do have to offer, this is what we call the Moscow Circus provision around 1990. Yes, that's how old I am. The Moscow Circus got stranded. This provision also applies to H's, O's, P's, and other kinds of visas. Can a student travel during the Cap-gap period? I knew I was going to get some tough questions. Simple bottom line is that the there's such a long list of questions. The individual can travel at certain times during Cap-gap, but getting a new visa that is an F1 visa is very, very difficult. I need the specific facts of the case in order to answer that one. I've answered that one. Blanket L1s, how many L1s can be processed? Good question. The limitation, for example, in India, they've now centralized all the blanket Ls in Chennai. They're watching. So, you've got to make sure that you meet the legal requirements, because they can be very tough on that. Is it my computer? Yes. Do we have to revoke the H-1B if the employer voluntarily likes to keep the H-1B active as part of the 485 backup in case the 485 is denied? Wow, another great question. Simple bottom line is that we do in fact encourage keeping underlying H-1B status. It's a generally good conservative position, which I encourage people to, in fact, continue to pursue. We do, unfortunately, have more questions, and I'm just seeing that we are sadly out of time at this point, because they're going to cut us at 2 o'clock. Thank you for joining us. Please join us again for our August 16th I-9 webinar, and it's been an absolute pleasure speaking online to you today, and please do reach out to us if you have any questions. Thank you, folks, and I hope you found this both informative and interesting and maybe a little bit entertaining. Until next time, goodbye, and please call if we can ever be of assistance. Thank you so much for joining.